Hey, hello everyone. This is chapter 13 that we're in now. And chapter 13 deals with the courts. And this is the third uh, of the three heads of our political system, of our infrastructure, which also sometimes is called the judicial branch of our government. And it is unlike uh, the other two branches. Because its primary purpose is really to determine the constitutionality of laws and how they go about the process of interpreting them. And so in this chapter, we're going to look at some things and we'll talk about some controversies regarding the court. And I think you'll see that the discussion question that I pose is one of the most controversial parts because the Supreme Court, or let's start with the Supreme Court, because that's the highest court, of the land in our country. Um, and unlike the other two branches of government, we the people elect the president, we the people elect the Congress, uh, and each individual has their own political, bias or their political interest by which they decide who they're going to vote for. The purpose of the justices, whether it's Supreme Court or any of the other courts, is to try to find individuals who are as unbiased politically and have great reverence for the Constitution when they talk about deciding on laws and policies, and that's what should be the foundation of what they're looking at, no matter whether they're liberals or conservatives in their own personal lives, or those who can look beyond that and be able to still have a reverence for law and policies, and even recognizing that the Constitution is 250 years old, more or less, or 230 years old, more or less, that we have to be able to look at it through different lenses sometimes and go, well, okay, laws that were interpreted one way, in 1791 may be very different today in 2024. So you also want justices who can, look at the law and then be able to also look through a newer lens in terms of how they interpret it. But still, you want them to be able to make decisions free of political influence. And that is unfortunately not the case of the courts today. And we'll talk about it as we get into this chapter. So let's jump in and take a look at the court system. So, first of all, there are multiple different types of courts, or different types of law, rather. It's not just criminal law. There's civil law, there's common law, there's constitutional law, there's administrative law, public law, and private law. And all these different entities are in place to provide, because the country has so many different levels of issues that reside within our infrastructure, that we need to have legalese, if you would, or interpretation of laws that are broken down, like based on business law, for example, things that drive how businesses are to cooperate or function, or those that deal with, private law, might be if you're going through a divorce, for example. So those kinds of things, you have to have laws in place, and they're all in place already. And sometimes we add to them to make sure that they, as we move forward in time, that those laws and policies are kept up with, looking through a new lens. But just to give you an understanding that there are multiple different levels to deal with the infrastructure of our country, to make sure for the accountability, and that we have a process by which people can be heard or have their issues looked at by justices. Now, we also have the UN, our U.S. legal system, we're broken down into what we call a dual system, because there's dual courts, both the federal and state level. They each have different responsibilities. The federal courts usually deal with national law and policies, and the state level usually deal with state laws and local politics and local policies. But then the infrastructure, there are three different levels of courts in both the state and the federal system, and that are the trial courts at the lowest level, and then the mid-level courts, sometimes called appeals courts, are called the appellate courts, and then the Supreme Courts are usually the highest courts, both in our federal system as well as in the state systems. And again, this gives you an example of that. So you can see the lowest level, the trial courts are usually for traffic and juvenile stuff. Also can be dealt with, of course, with like if you're going through divorce and small case, lower level cases. And then there's some states have state trial courts. Other states have, as you can see, have a appellate court, or sometimes called an appeals court, and that's most of the country operates with that at the state level. And then the state's highest courts are usually called state supreme courts, and sometimes they're called this appellate court at the highest level. So it depends on the state. Now, the development and growth of the justice or judicial system at the federal level derived from a very famous case, which was Marbury versus Madison, and this really sets up the notion. I'm sorry, I got distracted there for a second, but it's basically Marbury versus Madison, 1803, gives the framework for the judicial system to have what we call judicial review. And this basically means that the Justice Department looks at the legislative and executive branches as well as other administrative branches within the federal system, and also even along the states, to determine the constitutionality of laws. So that's what the purpose is that to review all the the laws and policies that are being put forward at the highest level, that they are constitutionally intact and that they are within the framework and justification of the Constitution. If they're not, then they can deem them unconstitutional and basically kick them or reject them. Okay. So if you look here, this just shows you the federal court system, and you can see within the federal court system, there are 94 judicial districts across the United States. So there's 674 judgeships within that. And then at the next level, the U.S. Court of Appeals, sometimes also called the appellate courts, there are 12 regional courts across the country and one federal circuit court. And there are 179 judgeships at that level. And then at the U.S. Supreme Court, the highest court in the nation, there's one Chief Justice and 8 Associate Justices. So there's 9 total. There's been many discussions about increasing the number of justices on the court. And there are lots of pros and cons of that, but that's something we'll talk about later. And then to your right, for the military courts, as you can see, there are U.S. military courts that deal with issues regarding military personnel. And then they also have their Court of Appeals for the armed forces. And then from there, the military cases also go to Supreme Court. So all whether it's military or civilian courts, they all, at the highest level, they go to the Supreme Court for discussion. So in terms of the systems of justice, we have what we call the adversarial system. This is basically the general structure of the court during civil litigation. There's a plaintiff, right, the person who is bringing the complaint, and then there's a defendant, and then there is so the plaintiff is bringing the case of what their issue is. They bring their complaint, why they're going after this other person or this company or whatever, and the person who they're going after is called the defendant, and then the evidence is called discovery. And that's basically the structure within most civil litigation, and also criminal as well. In the criminal, there's also what we have called a grand jury, and then there's an indictment, meaning that the person is being brought up on charges. And then typically there's a plea bargain, meaning that if they may say, okay, if you plead guilty to the charge, then you get less time, for example. Or if you tell us who the other people were who were involved, then we will give you a deal and let you have less time, in jail, or maybe get charged less money for your actions. And then over the last, 200 years approximately, there's been many cases that have increased the power of the justices, and certainly, as I mentioned, Marbury versus Madison was one of them, but also McCulloch versus Maryland, and then the Martin versus Hunter. These are all cases that by virtue of judicial review have fortified the power of the courts to be able to change policies and laws or drive them across all the national and state interests. Now, the limitations of the courts cannot initiate or maintain lawsuits. This is also what I would argue somewhat of a controversial issue because, like, while, for example, the Supreme Court cannot initiate a court, they can certainly, by virtue of how they choose, what cases they choose, um, they can decide how that looks and which cases they want to take on, and by virtue of the case they take on, can actually determine the outcomes nationally to some of the things that are most important, like Roe versus Wade, the abortion issue. Um, they selectively decided to take that case. They have a very conservative court now, majority conservative. So they could have either, when this case was brought to them, they could have said, no, we're not going to hear this and kicked it back to a lower court. But they chose to take this case. And because they basically only hear 2 to 2.5% of the cases that come their way. So imagine that. They'd say if they had 100 cases coming their way, they would select only 2 of them to be able to work on. So that's a pretty powerful place to be and gives you the ability to select more carefully which cases that you actually want to bring forward. Now, again, I'm showing you some of the process. So there's a nomination process, particularly this at the Supreme Court level. So usually the president, picks somebody who is ideologically where they are. So that's one of the key issues that I think is controversial about the court is that it doesn't allow to look for unbiased judges. People look for people who are aligned with them politically, instead of looking for people who are solid, unbiased, constitutionally sound, visionaries. And unfortunately, that's not the case these days for the most part. And that's unfortunate that we have found ourselves in a situation where the judges that's the only part of our government that I think is flawed, in my opinion, and that is that the president should never, ever, ever have the right to select or nominate justices. I think that skews the problem. I'm not saying I have an answer for another way around, but my issue is that on either side, the president has their own bias, and they will replace people at the federal level and at the highest levels of the courts to serve their interest. And I think that is a terrible precedent to set when you make them more political than they need to be. So a lot of this is based on, again, because of that, they look at it. So how do those justices look, or the candidates look at the particular policies or interests of the policies of the president or that political party? And if they align with them, then they're more apt to be nominated. Secondarily is the judicial competence. What they go back and look at their history to see if they have been made good decisions or relevant decisions in terms of their legal knowledge and decisions that they make on cases. And unfortunately, the last one is political loyalty. And I think that's where the problem inside the court system resides now, is that even the reverence for the law is secondary to their political loyalty. Sometimes the demographic factors are part of the process, and the current political environment can certainly play a part, even though I think that's happening less and less these days. There used to be a lot of public scrutiny, and I think sometimes there is. It just depends on how visible or how political the individual is who's being nominated. I think those who are more moderate tend to have a better, easier to swallow for the public. And again, they can, the infrastructure of the courts and the political system at the Congress and the president can either make this more publicized or less publicized, depending on the individual they're trying to place on the court. We've had a couple that have gotten in the door now who are highly controversial coming in the door because of their own personal beliefs and actions. So that becomes a bigger problem, trying to get them approved. And sometimes we approve people who have some very bad history behind them, which is unfortunate at the highest court of the land. The other problem I will tell you, that my concern with this is the fact that they actually have lifetime terms at the Supreme Court. I think that's a very bad precedent, in my opinion, as well, that there should be no branch of our government where anyone has a lifetime term. And the founding fathers probably did this because back then people didn't live that long, and they probably trusted that these people would do a job and have reverence for the Constitution, not for be politically motivated as they are today for a lot of them. And then this talks about the process of how the Supreme Court hears cases. And I'm going to go to the next slide because this will give you a better window. So basically what happens is, at the very lowest level, there's a judgment that's usually made at the state level, So you have two different entities here. One on the right is for U.S. The second one is on the state. So I'll start with the state level. Then they pretty much follow a very similar path. So let's say you file a case at the local level and you don't get the answer you want, and it's the state of California versus you. And then just say you feel like that they kicked it out or said no, or they said no, we're not going to deal with this. And then you file what's called a writ of certiorari. And the writ of certiorari is basically like a document saying that you want the Supreme Court to hear your case. And you can see on the chart here, 97%, it's actually closer to 98% now, of the time the certs are denied by the court. So again, as I said, if you had 100 cases, 97 to 98 of them are going to get kicked back. They only pick the ones that they find of interest to them or they are politically motivated today, like Roe versus Wade. When the cert is granted, then both the parties, the party who is filing, the one who's filing to, like say, for example, if you're challenging the state, you would file your brief or your argument for why you think your side is right, and the state would file its side as well. And then it goes for oral arguments to the Supreme Court. The Supreme Court then they assign opinions, drafting their, whether they agree or disagree with you, and then a final judgment is decided by the Supreme Court. Similar on the U.S. Court of Appeals, the same thing happens. The final judgment in U.S. courts, and it goes through a similar process. The only difference is here at this level, the third parties here, they file what's called an amicus brief, and that's the only difference between. It's similar, very similar though, but they just call it something different before it goes to oral arguments with the court. But this is the process by which the cases get to the court. But as you can see, very, very, very few of them get there. The other ones are kicked back to the lower court. And usually not the state court, but usually to one of the lower level courts, like the appellate court or appeals court. And then at the end of this, as the case proceeds, there's a majority opinion. But the justices either have a majority of the justices who agree with it, you'll have a majority of justices who concur with the opinion, and then you'll have those that are dissenting. And usually that's the way that, and they each have to write why they either agree, or concur, or why they concur or why they dissent. So you can have a majority of people, of the justices who dissent or disagree, or a majority who agree. And so the agreement is concurring, dissenting is disagreeing. So the reason why justices vote the way they vote, of course, some of it should be based on legal precedent and rules of law. There could be circumstantial issues. It could be ideological, like based on their own experiences and attitudes. And some of them back in the day were incredibly racist and sexist. So a lot of their own personal baggage can come up and really, drive how they decide on the court cases. The various inside the bubble politics inside the court. A lot of times people don't realize inside the Supreme Court there are many personal battles that go on because of the ideologies of both sides. And then also sometimes if there are political pressure from outside, from the public. That's why with Roe versus Wade, they tried to push it through very quietly because they knew if it became very public, that the political pressure to not overturn Roe versus Wade would have probably blown up in their faces. Not that they would still not have decided to take it down, but it may have been more pressure if they made it more public. Because it wasn't very public, and that was pretty unprecedented because usually when laws have a history, and Roe versus Wade had been in the books for over 50 years, usually the justices will make the decision and say, well, you know what, normally in a case like that, you go, okay, 50 years is a long time to have this law in the books, so we're not going to bother with it. So it's rather unprecedented that they would take apart a law that had been in the books for that long a period of time. Then, the idea of judicial restraint versus activism is really the idea by which justices, some justices are more active in certain cases, but only potentially, I would say more so in political cases. One, it enhances their careers, unless you're Supreme Court, you're at the highest level anyway. But for the other cases, it really, if you're a lower level judge, like a federal judge or an appellate court judge or appeals court, or even at the more local level, state courts, these kind of cases, certain cases can build your career. So you'll be looking for the cases that are really hot cases. you'll see the justices or judges be more active because it's enhancing their own career path to go higher up into another level of court. Judicial restraint is when the justices basically let all the case merits come out before, and then they just kind of let the process go without being so directly involved. So usually lower level cases, they kind of just let the process go without any interference. Again, the struggle of law versus politics is an age-old issue within the judicial system. This is one that I think, again, will be ongoing because the politics have really interfered with the ability for our judges to be able to be fair, as unbiased as they should be in making decisions for the betterment of all of us. And that is it for chapter 13. If you have any questions, I will look forward to talking to you in class. And I think you'll find the discussion question for this chapter be interesting. I look forward to reading your comments. Have a good one, you guys.